Stuart.
Good morning, my lords. Lords, I appear in this matter with Mr. Salman Bugdari. Learned friends, Mr. Quiney, Queen's Counsel, and Miss Atkins appear for the Chubb respondents, and the learned friend, Mr. Scory, Queen's Counsel, appears for the remaining respondents.
Yes.
My lords, there are two sets of issues in this appeal. One is the proper approach which the court should adopt to the grant of the injunctions in this case. And the second are some issues of construction. I propose to deal with the first matter first, not least because it involves, in my submission, your lordships being one of the two relevant prisoners in a prisoner's dilemma, the other relevant prisoner being the Supreme Court of Alberta. And in those circumstances, my lord, it seems to me that I should tell you why it is that you're a prisoner before you come to consider the issues of construction which unquestionably arise. My lord, this case is somewhat unusual in this respect. If your lordships would be kind enough to look at any one of the what has been referred to rather inelegantly as the PPJC, which are contained in the core bundle and are in the same form. And if we could go to the first of the PPJCs, which is to be found at page 94, tab 9A. On the face of this clause, insurers made three promises. The first promise was that it was understood and agreed by both the insured and the insurers that any dispute concerning the interpretation of the terms, etc., of the policy are to be subject to the same law and the same jurisdiction as the primary policy. The second promise was that each party, so including the insurers, agreed to submit to the jurisdiction of any court of competent jurisdiction within said territory. For reasons which are set out in our skeleton, which I'll come back to on construction, we say that said territory in that clause means any of the territories where there is jurisdiction granted by the primary policy, and to comply with all requirements necessary to give such court jurisdiction. And the third promise was that all matters hereunder should be determined in accordance with the law and practice of such court. Unlike, therefore, any of the cases which are considered, with the possible exception of generale at first instance, the case before you involves two sets of promises. On insurers' case, in relation to the three remaining policies which are in dispute, my clients agreed to the exclusive jurisdiction of the English courts. On my case, insurers agreed to be governed by the same law and jurisdiction as the primary policy. It therefore follows that there are two competing positive promises, and precisely the same jurisprudence can govern either. Now, in this case, insurers rushed off and got an ex parte injunction. They didn't do it all together. They did it in two bites, with Mr. Scory going first, and then leading the laggardly Mr. Quiney to the well of judgment. The matter then came back on a return date at relatively short notice before Mr. Justice Jacobs. Lord, if, however, the jurisprudence is good, and if one could persuade the Canadian court that what is being done in relation to this clause is insurers being guilty of precisely the same vice of which they accuse my clients, then what you have got is two jurisdictions. And the Canadian court could say, look, you insurers have decided or have agreed to be bound by the same law and jurisdiction as the primary policy. There is no dispute that the primary policy is the primary policy which provides cover and which is being sued upon in Canada, in Alberta. You've agreed, you've promised to submit to the jurisdiction of that court, and in those circumstances, you running off to the English court is a breach of that, or would be a breach of that, and that we are therefore going to grant an anti-suit injunction.
It's not an uncommon situation. We quite often have two jurisdictions, both granting anti-suit injunctions.
No, my lord, but it does give rise to this prisoner's dilemma. I'll come back to the commonality, but accepting your lordship's premise, I wouldn't accept, for reasons I'll come to, that it's very common to have two positive averments in this sort of situation. If one looks at the cases which are put forward, one doesn't find that. One finds often a dispute, and whether there's natural law, but positive promises which are conflicting is not that common. But leaving that to one side, accepting, as it were, the premise of your lordship's question, one then gets, well, how is it that this is a prisoner's dilemma? And the answer to that, my lord, is to be found in what comity actually means. And for these purposes, I will look, if I may, briefly with what was said in EcoCam. There are two aspects of comity which are relevant. One is that one should be extremely careful before, as it were, asserting rights which infringe those of a foreign court. And the traditional English response to that in relation to anti-suit injunctions has been, well, we're not infringing any rights of the foreign court, all we're doing is enforcing the bargain which is made. What can possibly be the matter with that? That is not universally accepted, and the English jurisprudence shows that there are concerns about that, and when one looks at the Canadian jurisprudence, including the Canadian Supreme Court, one sees those concerns being expressly identified. But the second aspect of comity, which is apparent directly from the EcoChem case itself, is the concern about wasting of time and costs in parallel jurisdictions. Now that is a real concern when what one is doing is causing a real dispute, and let us accept for present purposes that there is a real dispute here between clauses in a policy.
Well, that's one of the questions, isn't it? Because on the judge's approach, there isn't. He said that the primary policy jurisdiction clause didn't apply. It had nothing to bite on because there was no jurisdiction clause in the primary policy. And if he's right about that, and of course that's one of the issues, then we're not in a conflict of clauses situation at all, are we?
Well, my lord, of course I accept that if one is in a situation where one cannot, as it were, give any meaning to this primary clause at all, or it wasn't there at all, we wouldn't be there. The point, though, for present purposes is this. Given that his lordship had to accept and deal with some quite detailed arguments about what the PPJC meant, then the fact that he had to deal with those, in my submission, does raise the very question which I was seeking to address, is what is the appropriate test for granting an injunction here? Because simply to say, oh well, for example, we have to be satisfied to a high standard that one is right, raises the very real prospect. The equivalent of Mr. Justice Jacobs sitting in Canada could come to a precisely contrary conclusion. And my lord, of course I accept the premise of your lordship's question, which is that if there is no real dispute whatsoever, then what I've been putting forward isn't there. But in a sense,
if we accept that the high threshold has been met, then don't we just proceed on the basis that that's right? And we don't start then worrying about whether, despite the fact we think there's a right answer, the Alberta court may come to a different conclusion.
my lord, with respect, that is a dangerous line to follow. First, there is no definition of what is meant by the relevant test.
No, but then nor is there a definition about what is meant by your proposed test of a real doubt.
Well, my lord, there is no precise test, but in my submission, the point that I'm making at the moment, which is the prisoner's dilemma, which I haven't actually made quite yet, but which is why it is relevant, is this. You want this determined once properly on proper notice, not by people rushing off for injunctions in order to get enormous time and cost, to get first mover advantage before the commercial court, and then come back. That is wasting everyone's time and money. And when one looks at what was said in EPCAM, that is what one is trying to avoid. And, my lord, therefore, what I say is this, and the reason I've dealt with it at this point, is that when one looks at the difficulties which Mr. Justice Jacobs' conclusion come to, one has to remember that what is being said here, the basis of the jurisdiction, is that my clients have effectively done something which they ought never to have done, i.e. issue proceedings in Canada. And it's that which founds the jurisdiction for saying, you are naughty clients, you shouldn't have done that, we're going to injunct you and prevent you from having access to a court of their choice. And, sorry, just to finish that obvious point off, that is a serious matter.
Just before you explain exactly what you mean by the prisoner's dilemma,
Yes.
I was a bit puzzled in some respects by the order which the judge had made and the impact of the high degree of probability or whatever alternative test might be. His order is headed interim order and it applies until further order of the court, but it seems to me that once a court decides what the true construction of the relevant policy is, there is nothing left to be decided, is there? And I don't think, as far as I can see, no provision was made for further proceedings in the court below, and therefore, why didn't the judge simply say, I've had full argument? Looks as if he had, and he produced a very full judgment. This is what the contract means, and it can be finally decided.
Well, my lord, there are probably two answers to that. So far as why he didn't do it, I need to actually remind myself of the precise circumstances as to whether he was asked.
And maybe nobody asked him to. This didn't arise.
And I do need to just check whether that's right or wrong. My memory is there was some discussion at this point, but I'm afraid I haven't gone back and reminded myself. Maybe someone else can remember, but I at the moment can't. But we can check that.
Okay.
The second, which is certainly this, is that in my submission on this sort of case, whereas here the scope for further factual argument would be extremely limited, and I say limited for one reason I'll come back to. Your Lordship is broadly correct that in a sense once it's been looked at and determined why would you want to come back. There is one point upon which further evidence could potentially have been relevant, and that's the Scottish law point.
But all injunctions obtained until the end of the trial, as it were, when they may become irrelevant. In a sense, they are interlocutory injunctions, but nobody's going to argue about them again. I'm not sure it's particularly unusual or particularly there's any particular concern over whether it's described as interim or final. Is there?
Well, my lord, I wasn't actually addressing that point directly. As to the theory of the matter, the existence of as it were, short-form determination of this point, which excludes the jurisdiction of another court, it is not in my submission to be taken lightly, which is not directly on your Lordship's point. But just to explain why that is, the consequence of this is the certainty of fragmentation of disputes, which is contrary, in my submission, both to the natural meaning of the policies, read collectively and together, but also to manifestations of what has been referred to as one-stop adjudication. And the point I was on in developing the prisoner's dilemma matter is that actually doing this in a rush is not satisfactory. I appreciate I'm coming in off a long run, and you probably want to see what the punchline is.
But I mean, nobody's saying, are they, that the judge did things in a rush? I mean, maybe the initial without notice applications were done in a hurry, but it all came back with full argument. Teams below pretty much as they are here, for Mr. Pryor as well, so even more. And the judge then produces a full and carefully reasoned judgment. So to say you mustn't do it without being cautious or extremely careful, or whatever expression you want to use, I mean, the judge was extremely careful, but that's the conclusion he came to.
Lord, could I just show you what I mean in the judgment of Lord Justice Christopher Clark in Ecobank, because I think it's time that I actually bold the ball. It's tab 10 of the authorities bundle. And this was a case in which...
Can you give me a page number?
Oh, I'm sorry, Molly, 278.
Thank you.
Always assuming it's one of those rare cases where the PDF numbers actually match the bundle number.
No, it isn't. Or yeah, maybe.
But nearly.
Yes.
It's better than it often is.
No, it's one out.
Yes.
Your Lordship, tell me which way so that I can do the arithmetic hereafter. I'm sorry about that. I'm afraid it's one of those occasions when one tends to work either from paper or from hard copy, and doing both, I'm afraid I haven't done. I do
278 is 279 in the electronic.
But I was intending to refer to the first page of Ecobank, which is where one finds it, tab 10.
Yeah.
My Lord, this was a case where there was an arbitration clause, and the issues in the case really revolved around two matters. One was the width of the arbitration clause, but more substantively was the fairly substantive delay which had taken place in relation to the challenging proceedings which had taken place overseas. So that's the context in which the discussion has taken place. And the arbitration clause is to be found at page 200. Well, it's to be found at internal page 2234, page 281 of the hard copy bundles. And one sees a fairly conventional arbitration clause in clause 26 and 28, a governing law and jurisdiction clause subject expressly to the arbitration clause in clause 28. Lord Justice Christopher Clark went to address the question of whether or not to grant an injunction at page 295, paragraphs 80 and following. And for present purposes, this is fairly familiar ground, but he records accurately at 83 is that the English approach to the grant of some such injunctions is that reluctance has almost evaporated with an appreciation of the fact that when the court grants an injunction, it doesn't direct the foreign court to do or restrain from doing anything, something which has no power to do. It acts in personam, enjoining the party who seeks to litigate elsewhere from doing so in order to enforce the contractual undertaking that that party has given. It seeks to give effect to the bargain that parties have made, and he goes back to the 19th century injunctions to deal with that. And he then deals at paragraphs 89 and following with the threshold test. And what was being submitted was that there should be a lower test in the case of an application for an anti-enforcement injunction, and Lord Justice Christopher Clark rejects that in the passage headed C change at paragraph 91. And then he discusses what is meant by comity And he records the submission at comity in paragraph 94 from Mr. Coleman is to ensure that the agreement of the parties, here is to arbitration, is respective. Delay is no bar to injunctive relief unless there has been detrimental reliance. And he then cites from another number of cases, including OT Africa Line, where he sets out the judgment of Lord Justice Longmore at paragraphs 97. And just below letter F, you see Lord Justice Longmore saying the doctrine of comity requires restraint, since another jurisdiction may take the view that the courts of that jurisdiction are an equally or even more appropriate for than the English court, and any anti-suit injunction can be perceived as at least indirect interference with such foreign court. And then goes on to say that in the case of an exclusive jurisdiction clause, comity has a smaller role. It goes without saying that any court should pay respect to another foreign court, but if the parties have actually agreed that a foreign court is to have sole jurisdiction, the true role of comity is to ensure that the parties' agreement is respective. And then, if one goes forward to the substantive discussion by Lord Justice Clark and goes to paragraph 132, he's rejected the submission of paragraph 131 that should be a difference between anti-suit injunctions and anti-enforcement injunctions. And then he says this at 132. Comity has a warm ring. It's important to analyse what it means. We're not concerned here with judicial amour propre, but with the operation of systems of law. Courts around the free world endeavour to do justice between citizens in accordance with applicable laws as expeditious as they can with the resources available to them. This is an exercise in the fulfilment of which judges ought to be comrades in arms. The burdens on courts are well known. Long list, size of cases, shortage of judges, expanding waiting times and competing demands on resources. The administration of justice in the interests of litigants and courts is usually prejudiced by late attempts to change course or to terminate the voyage. If successful, they often mean that time, effort and expense, often considerable, will have been wasted both by the parties and the courts and others. Comity between courts, and indeed considerations of public policy, will require, where possible, the avoidance of such waste. Now, why am I citing that? Well, I'm citing it because when one gets to the decision of the Supreme Court of Canada in Amchem, one sees that in the leading decision in that case, the courts have set out very carefully how it is that one should approach anti-suit injunctions in Canada. And what they say, in effect, is that anti-suit injunctions are one of two mechanisms for dealing with breaches of agreements or exclusive injunctions. One is a stay. That stay being sought in the jurisdiction where the anti-suit injunction is being infringed. The second is an anti-suit injunction. Now, the justification here for, as it were, as I said, rushing off to the seat of judgment was a perceived risk that otherwise we might go for an anti-suit injunction. Now, that was the subject, as it were, of a part of my complaints about non-disclosure, which isn't before you, but let's assume there is some small risk of that. If both England and Canada operate on the business that you can rush off because you're worried that Canada might effectively get the decision wrong or that a stay shouldn't be granted, what you're actually doing is encouraging litigants to go into an extremely expensive process, rush off to the seat of justice, and do so even in circumstances whether it's absolutely plain that there is a legitimate dispute to be decided. Now, my Lord, I accept, of course, Lord Justice Mayall's point, but that begs the question that I'm coming to, which is there here a legitimate task? My submission at this point, before going into the construction, is that it's completely obvious, if you look at the PPJC, and you look at either Clause 11 or 12 of the global umbrella, the first excess and the second excess, there is a problem. And for present purposes, I don't need to go any further than that. My Lord,
are you submitting that the proper route for insurers to take was to seek a stay in Alberta?
Yes, absolutely.
And that any other course was improper?
I would say that impropriety is something which I don't want to bandy around. What I would say is that in the circumstances where you've got two competing jurisdictions, the English court should not, as it were, encourage people to do what has been done by insurers by granting an injunction. That's as high as
if they have the benefit of an exclusive jurisdiction clause, why should they go and litigate in Canada?
Well, because, my lord, there is a legitimate dispute as to whether they have or have not.
But that's the question that is being decided in the first instance by the English.
Well, but my lord, with respect, it's also obvious that if they're wrong about that, they're acting in breach of the injunction.
But if you're not setting up a procedural bar, which I understand your last answer to be you're not, what's the point of this submission?
And where is this procedural bar in your grounds of appeal?
Well, the procedural bar is in relation to comity, is to the proper approach as to how one should, what the minimum test should be, and comes down to how one should get to it.
But that's this is ground 1.7 of your grounds of appeal, isn't it?
My lord, yes, it's the proper approach as to where one should get to it.
But I don't see that your ground 1.7 raises that question. All you say is that the judge, he erred in being satisfied to the required standard. You don't challenge the required standard. Have I missed something? This is all under the heading interpretation, as I understand.
My lord, in relation to the grant of the injunction, yes, alternatively, the learned judge erred in being standard that it should be given so just in circumstances there are conflicting or potentially conflicting causes of the jurisdiction. The conflict meant that the appellant's case that was an exclusive jurisdiction could not be clearly demonstrated at the necessary standard.
That's not a procedural bar. Yeah, you've got to come off the fence, Mr. Stewart. You're either saying it's a procedural bar, or you're simply saying you don't like what they've done, but it's not a procedural bar.
Well, I don't think I've submitted that it is a procedural bar when I was asked the question first time round. So
Are you saying the judge erred in the standard he chose, he applied? I'm not really sure what the ground of appeal is here and where we find it.
Well, my lord, so far as the relevant standard is concerned, so far as the skeleton argument is concerned, you'll see what we said in our skeleton argument in relation to the required standard. I would say that is covered by 1.7.
Can you explain how?
But it's all under the heading, the learned judge erred in preferring clause 11, and as my lord pointed out, under the heading of interpretation, which, as I understood it, was saying the judge reached the wrong conclusion about the true construction of the policy, whereas it seems, perhaps I've misunderstood, but it seems that you're now saying he shouldn't really have embarked on this at all, but should have left it to the Canadian court.
Well, my lord, I do. I do say that one of the reasons for that is the consequences of what is being done. My lord, I see a certain amount of judicial resistance at the moment to the propositions that are covered within the grounds. Can I deal with the questions of interpretation and then consider whether or not I really do need either to persuade your lordships that what I'm saying is within the grounds, or that I need to seek permission to amend at what would no doubt be a rather late stage to the grounds.
All right.
Lord, can we just, with that, have a look at the policies? Lords, one of the things which occurred to me yesterday was that although the judge referred to two other policies, you hadn't been provided with them. I've got them here if there is a burning curiosity to see them. I, for my part, have had them copied, not because I propose to take you through them, but because, as I say, they're in the judge's judgment, they're referred to, and it did seem to me that it was at least possible that there will be some judicial curiosity as to what their terms were. I say that simply, you know, they're there.
Well, sorry, which of the policies you're offering?
So, my lord, we've got in the supplemental, the supplementary bundle for the appeal, the full terms terms of the umbrella policy, which is at 66. What you haven't got is the primary policy, which it is now agreed was there, which is the CGL policy. It is agreed that that has no express choice of law clause or choice of jurisdiction clause. And that was the basis upon which everyone proceeded, thinking you didn't need it. But given that we are talking about a tower of policies, we have got that there. In addition to which, there are two other policies. That's the so-called non-USA, it's global non-USA policy. There is an equivalent USA policy, and there is also what is referred to as the Beasley Policy. The global umbrella sits above all three, but the primary policy is the CGL policy.
Well, I have in front of me all the time in this appeal the diagram which was provided, because otherwise it's quite hard to understand some of what's being referred to. I think for my part, I don't think I need to see those further policies unless something comes up in the argument which we need to go to. If my lords would like to see them, then obviously they'll say so.
Lord, I'm simply telling you that, as I say, there are three policies which are referred to expressly in the judgment below, which we've got here, but you haven't presently got.
Right, fine.
My Lord, can we go to the global umbrella policy, which is to be found at tab 5 of the supplementary bundle? And obviously from this, in the core bundle, are extracted the key clauses. But there are some other clauses which I would like to show you when one goes through.
Have we finished with Lord Justice Christopher Clark for the time being?
We have finished with Lord Justice Christopher Clark for the time being. Now, my Lord, as the judge explains in his judgment, the forms of the policy with which we are concerned are now in Lloyd's Standard Market terms, and one sees them at page 66. And what one sees at the top is a passage headed Risk Details, then a unique market reference, and then the type of policy. These, as it were, the headings down the left-hand side are in standard form. And they arose out of the entirely unwarranted concern expressed by regulators that every so often policies published in the London market weren't completely clear as to what the terms were. And they superseded that with which we were all brought up of slips and issued policies. Just to, as it were, identify on this policy, one sees type, global umbrella, including, and then there's a whole series of types of cover. The insured, my clients, John Wood Group PLC and subsidiary companies as declared, principal address given in Scotland, the period, and then one sees the interest being described. If one then goes over the page, you'll see limited liability, which is $15 million each and every occurrence, and 45 million in the aggregate, in excess of various underlying limits as follows. And what you see over the page is a whole series of underlying policies. Now, my Lord, this being an old schedule of policies, what you find here includes the policies, and if you look about 2/3 of the way down the first page, is a general liability policy, which has got a policy number and so forth. That's not the same policy number as the one we get to, because by the time we get to it, we're in a different year. But this is the schedule of policies which, as it were, underlie this global umbrella. If you then go forward to page 71, you'll see some provisions about special agreement. And 72, you'll see conditions, wording as attached. Now, as the judge made plain, this policy, 7 of 30 in the top right-hand numbers, or as he accurately observed in one of the policies cases, 32 of 30, contains all of the, in other words, the whole of the document is within the document. But the conditions as attached, must refer to the conditions which start on page 25. And then page 73, which is where we get to the PPJC, territorial limits, worldwide, including USA and Canada, primary insurance company, ACINA insurance policy number, and then a policy number is set out. At first instance, there was a dispute as to what that means. There is now no dispute that that is the primary policy which is being referred to. Choice of law and jurisdiction, which I've already read out to you, just to flag some obvious points. On the face of this, this is an operative provision. It's not something which says look elsewhere for an operative provision. It is saying any dispute concerning the interpretations of the same is to be subject to the same law and same jurisdiction as the primary policy. That obviously begs the question, what is the same jurisdiction as the primary policy? What is the same law as the primary policy? But that is simply like saying, as one does often in contracts of insurance, this is to be found, the libel rate is to be as published or something like that. It's not incorporating another document, it's referring. The operative words or the operative conditions are contained here, and for present purposes it is a relatively important part of my argument that it doesn't simply say conditions to be as found as in, for example, in the generally a particular form of contracts. The same is true, each party agrees to submit to the jurisdiction of any court of competent jurisdiction within the said territory. All matters arising here and under should be determined in accordance with the law and practice of such court. Now, on the judge's findings, these words at the front of the policy were given no meaning at all. They have to be disregarded. Now, one of the submissions I shall make when we've been through the policies is that policies or contract documents, like books and like people, are more often recognisable from the front than they are from the back. And I shall draw some support from that, from what has been said in cases, in particular in relation to bills of lading and so forth. But for present purposes, my stress is that these are operative provisions which the judge gave no meaning at all to. Then if we go over the page, we see various provisions as to premium payment terms and so forth, all of which are matters of some importance. We then go through various listings, and then when we get to page 82, 17 of 30, we see an extended period agreement which deals with the extension to the 30th of January of 2017. Then we come back within, as it were, the headings which are required by the form to reinsurers' liability at page 84. And we see then the signing provisions at 85, and at 87 one sees the written lines. And then we get a particular excess combined liability provision at page 24, and then we get the conditions starting at page 90, 25 or 30. For what it is worth, these conditions are in slightly smaller type. They start off under interpretation at 1, saying this policy and the schedule shall be read together as one contract, and any word or expression to which a specific meaning has been attached in any part of the policy of the schedule shall bear such meaning. There is no express schedule here. This looks like a set of standard terms and conditions which have not been designed for this policy. If one goes down, one sees alteration, no amendment to any of the primary policies or any underlying excess policies making any change in its terms or conditions shall apply to this policy unless agreed in writing by the company. Again, this looks like standard terms and so forth. And then we get to the choice of law clause.
When you say standard terms, are you able to identify it as a particular standard form, or are you really saying they're Marsh standard terms?
I'm not saying they're Marsh standard terms, my lord.
Are you saying this is a form of?
I am not saying that this is a form of specific standard terms.
So you're just saying they look like standard terms?
I am saying that
because they don't fit terribly well.
Yes, essentially. I mean, the only reason I was hesitating is that in some respects don't fit at all. But yes.
Well, another reason for hesitation might be that the same is said for the bit. Could be said for what's at the front of the policy.
Well, my lord, the difference about that is this, that so far as the front of the policy is concerned, plainly very large bits of that are specifically negotiated because one sees that in terms of how the risk is put together and so forth.
Well, that touches on a point which I'm sure we're going to come to, which is what is meant by specifically negotiated.
Well, I will come to that. Can I just take you relatively briefly through the rest of these terms? We then, of course, get to the choice of law clause at 11, and your lordships have the point, because you've seen it already, that this 11 says this policy should be governed and construed by in accordance with the laws of England, Wales or Scotland in respect of any policies issued in Scotland, and except in the case of Scottish policies, the Commercial Court of the Queen's Bench shall have jurisdiction in respect of any dispute under this policy. It's not with respect to the draftsman, even by itself, the most absolutely pellucid of provisions. One of the observations made is, well, what does it do in respect of a policy which is issued in Scotland in relation to the existence or otherwise of jurisdiction in relation to England? And if it's said that it is exclusive, how does one deal with that? I put those matters to one side for present purposes, but the observation I'd simply make is that simply looking at this as a clause, unlike, I would accept, Clause 12, which we're going to have a look at in a minute, it is not the clearest of relevant clauses. Lord, what then happens is that the back of the policy then goes back to page 96, construction, administration agreements and so forth, and one here sees subscription agreement of 97, claims agreement between the parties and so forth, and other matters. Lord, the next policy is the first excess, which is at page 6. It follows the same general form as previously. There are some differences. If your lordship would look at the 106, one sees territorial limits as per primary, conditions wording as attached, plus amendments as necessary to provide cover as described hereunder. And then, of course, when one gets to the terms, the conditions, one sees actually quite a different set of conditions at 132. In other words, this isn't just a slight change on conditions. One sees at paragraph 1, the term ultimate net loss shall be understood to mean the actual sum paid and settlement of losses which the insurers are liable, and so forth. But clause 12 is, I would accept, what is on the face of it, a clear exclusive jurisdiction clause. Then you have, at 7, the second excess policy. Now, your lordships know that this policy doesn't contain anything in the conditions so far as exclusive jurisdiction is concerned. It does, however, for the first time raise the issue of Allied World, and you see how this is done. Allied World, being one of the insurers subscribing to the agreement, appear to have caused a number of changes to be made to the policy. At page 152, 7 of 26, you see the insurer reserves the right to increase the premium at the 31st of January 2016, and then 1, if some particular incident causes a problem, and 2, any other claim or occurrence exceeds £12.5 million, all amounts and calculations to be agreed by Allied World. And if you then go forward to page 159, you see under choice of law and jurisdiction, Allied World does not follow this clause. Allied World endorsement number 1 to apply with Allied World's stamp. If you go to 168, which is dealing with written lines, you see Allied World endorsements number 1 to 6 attached to apply to Allied World's participation. And if you go through to the indemnity limits at page 175, you see Allied World does not follow this clause, endorsement number 3 attached to apply. And then basis of agreement and contract changes at 178. Allied World to agree all contract changes for its own participation. And then you get the Allied World endorsements. And those endorsements start at 186. With a slightly unusual arbitration clause. I mean, it's obviously a valid arbitration clause, but it involves nomination with choice of third arbitrator with a default provision of application to the High Court. And the endorsement actually goes on over 2 pages and includes, for example, at the bottom of 187, provisions in relation to indemnity or contribution, and an express choice of law clause at 188. Now, my Lord, even I, at my most bold, couldn't submit to the judge below that this wasn't a valid and binding arbitration clause. The submission I put forward, was that in discretion a stay should not be granted in relation to it, and that's not the subject of an appeal. The point I would make for present purposes is that it is plain that Allied World, for whatever reason, have agreed with my clients particular provisions in relation to insurance, which obviously involve a, unless otherwise agreed to, of course, a departure from the otherwise agreed mechanism for resolving this dispute, these disputes. And then we get to the third.
I mean, one consequence of that, I suppose, is that whatever happens in this appeal, there are going to be proceedings in Canada and proceedings in England relating to this tower.
Well, my Lord, that depends, if I may say so, on this. By the time we get to the second excess policy, one will have had to have burnt through quite a lot of money.
Yeah, I see that possibility.
And, my lord, although obviously there is some force in relation to that, one can also see that alternative strategies could be deployed in relation to whether or not Allied World are really going to have a separate arbitration.
The claims against you are 250 million, aren't they?
Yes, it doesn't necessarily mean that we're going to go down to 200.
No, not necessarily. I grant you that.
I thought it was 450, but anyway.
My lord, the reason why they were in there is that potentially, of course, all of these are involved. But at the moment, the only claims for actual indemnity are in relation to essentially defence costs. So we haven't got to we haven't got anywhere really up the tower yet. My lord, then the third excess policy. Your lordships will now have got the familiarity in relation to this. The important point for present purposes is that Allied World is also on the third excess policy, so that you see the same forms of endorsement at, for example, 202. And just to see how this is all structured at 204, because this is, of course, is the top relevant policy, one sees that a tower is involved with an identified primary, which you haven't seen, but which we've told you about. The umbrella, which you have seen, the first excess, which you have seen, and the second excess, which you have seen. And so far as the Allied World endorsement is concerned to the choice of law and jurisdiction clause, at 209, the endorsement is against the PPJC. If you go through to the conditions, which are at 225, there's no endorsement to this. And the arbitration and choice of law endorsement for Allied World is the same as that which we looked at in the second excess, 239. Now, my lord, in my submissions, the questions of construction of these policies which properly arise are...
Before you get to that, in the third excess, where do we find the exclusive jurisdiction clause?
Oh, sorry, Lord, I thought I'd shown it to you there and make the point that it's not there. It's number 12
On page
226.
226. I just wanted to see if there was any
it's
Allied World not following that.
No, sorry, that was the point I was making, my lord. At page 226, there's no endorsement of that, saying they're not following that. Your lordships may think it only takes me so far, but the point I've obviously got is that when they sought to endorse this and, as it were, opt out, they opted out by scratching the PPJC, not by looking at condition 12 of the conditions starting on page 225. Now, my lord, the fairly obvious points that I make in relation to this can, in my submission, be divided up essentially into 6 headings. One is a matter which has already been raised by Lord Justice Stuart-Smith, which is the proper approach to a specifically negotiated term. and therefore I will need to deal with his question as to what is meant by a specifically negotiated term. The second is the proper approach where there is one common clause throughout a whole tower of insurance policies, which would, with the sole exception of the specific Allied World endorsements, operate together as compared with the varying and different jurisdiction clauses which are to be found in either 11 or 12 of the conditions which I've shown you. The third is the front versus back issue. The fourth is whether it is appropriate, as we criticise the judge for, to start off with a bias in favour of the clauses in the conditions and seeking to find whether there is anything to derogate from that in the PBJC. The fifth is whether, as the judge found, this was to be a case which is to be compared with where you import specific or alternative provisions into a contract as compared with operative provisions. And the sixth is whether it matters that within the primary policy referred to in the all of the policies you've been looking at as found by the judge and not challenged on this appeal, there is no specific choice of law or jurisdiction clause. Now, my Lord, I'm going to deal with each of those points. Your Lordships will not, I anticipate, be assisted by looking at the cases which, as it were, deal with the modern approach to interpretation of contracts in general. And the only reason why they are within your bundle is that it does appear that there may be a dispute as to whether the starting point should be that you look at the contract as a whole. I rather doubt that there is such a dispute. In my submission, on orthodox principles, your Lordships look at and start by seeking to give effect to all of the words which are contained within the contract. You do not start off with a bias or presumption in respect of any particular clause. Instead, you seek to identify what the commercial purpose of the agreement in general is, and insofar as relevant on particular clauses, what the clauses are which you are seeking to look at. And in my submission, that is made apparent from the authorities. If necessary, one can look at those in due course, but I very much doubt there is anything which is controversial in what I have said in those submissions. My Lord, with that starting point, in my submission, you have got on at least two of the policies you are considering, namely the first excess and the third excess, a problem, because the condition 12 in the first excess and the third excess at the back of the policy says they'll be subject to exclusive law, English law and English jurisdiction, and the PPJC says they shall be subject to the same law and jurisdiction as the primary policy, with the other provisions which are added out, the three warranties, the three promises, which I identified. My Lord, I make the following observations. First, the PPJC, without the exclusive jurisdiction clauses at the back end of 2 of the policies, 3 of the policies, serves what any businessman would regard as being a sensible commercial purpose, namely one-stop adjudication. Do you want to have disputes as to the application of these policies determined in numerous different fora? Or do you want the position to be that they are determined in one fora? That's point 1. Point 2. When one looks at the authorities, one sees that there is a strong case for saying that the law recognises the undesirability of disputes being divided up. And one can get that from the Fiona Trust case at tab 5 of the authorities bundle. House of Lords decision in 2000 and
that's the no rational businessman bit,
yes.
is it?
Yes, my Lord, yes. It's the passage at 148 which your Lordship has quoted.
Give me, what was the page number?
My Lord, the internal page number of the report is 256. The bundle page number is 148, and it's paragraph 40, my Lord.
Sorry, we're looking at
I thought we were looking at
tab
Fiona
5,
Trust.
aren't we? Your page
Oh,
number.
sorry,
Case
I'm
or your
terribly
page
sorry. I've just skipped over. I've just gone straight on to Deutsche Bank, which I didn't intend to. It's the page 130, paragraph 13.
Yes.
Number one, in my submission, reinforced in this case by the obvious interrelationship within the policies that you are considering. They all refer back to the same primary. They then all refer back to, in the case of the second excess, the first excess, in the case of the third excess, the second and the first excess, and so on and so forth. And they all have a clause in identical terms. Lord, to similar effect is the decision of the Court of Appeal in Deutsche Bank, which is at the next tab, and the relevant paragraph there is at 148, paragraph 40. And Lord, I accept, of course, my Lord Justice Mayall's point that in this specific case, Allied World, in 2 of the 3 policies, negotiated a different resolution tribunal. 2 points in relation to that. The first is that doing that showed the importance, as it were, of making clear that you were going to be doing something different. And second, that does not...
Different from what the rest of the tower is doing, or different from the rational businessman?
Different from what the rest of the tower is doing, and different from what the rational businessman would normally do. Well, just to make it plain, of course, Allied World's position is not entirely, as it were, risk-free. The rest of the market are going off and get a decision of a judge for these purposes, whether a judge in England or in Alberta, and decide to put Allied World's position to one side. It may be that, subject only to the Allied World endorsements, which your lordships have seen were not entirely the same, it would be a somewhat bold arbitrator who decided that they were going to depart from the provisions. But there we are. I accept, of course, that it could happen. The next point to make in relation to the points is the proper approach to a specifically negotiated term. My Lord, it is, in my submission, impossible to conceive that rational businessmen would have decided that you would have no express choice of law clause in the second excess policy, one providing for England, save in respect of policies issued in Scotland for two of the others, and that you would have those clauses in a different form. In other words, the very fact that you have in this tower these different forms strongly suggest that you have incorporated what is referred to sometimes in the authorities as boilerplate clauses. But by contrast, in my submission, the same cannot be said for the PPJC. Anyone looking at the policy or policies and looking, as it were, towards the front of them will say, well, if we're interested, we'll have to have a look at the primary policy to see what the law and jurisdiction is. But what we do know is that all of these policies are the same law and the same jurisdiction as the primary policy. Well, so far as the importance of front versus back is concerned, one of the authorities which is relied on by my learned friends is the Generali decision, which is to be found at tab 12 of the bundle, starting at, I hope, page 326. Now, these claims arose out of the loss of a vessel called the Capita Veselkov, which was a pelagic freezer stern trawler, which sank on the 5th of February 2017. And there were Generali and 22 other insurers involved under various hull and machinery and increased value policies. The typical problem arose, as one saw from the 2015 fleet policy, and you see the relevant terms of that at page 334, when Mr. Justice Foxton was discussing the fleet policy at paragraphs 26 and following. The parties to that policy were Generali, SEAT, Swiss Re, India International, and PICC, and you get that from just by letter D of the report. And the cover was set out in what was referred to as a cover note, although the judge pointed out that it wasn't a cover note in the traditional sense that a broker describes what the cover is that he's got, because it's stamped by the insured. And That's set out at 29, and it had, under the hull and machinery cover, English jurisdiction, subject to English law and practice. And he says he'll refer to this provision in both the 2015 and fleet policy and the renewal of that policy as the jurisdiction condition. And then, under increased value, all other hull terms and conditions deemed incorporated herein. And then the cover notes provided form, Commodley Policy, edition 1988. And that was a reference to a standard printed form. That standard printed form had at Article 2 over the page, contracts governed by Italian law, the English clauses attached to this policy must nevertheless be interpreted and applied as they're interpreted and applied in England. And then jurisdiction, any dispute in connection with this contract is solely subject to Italian jurisdiction. Competent court at plaintiff's option is solely the place of the residence, the head office of the company, or the agency having charge of this contract where the contract is being concluded. So you had there a conflict between express terms printed on the cover note, English jurisdiction, and a form which doesn't say anything on the policy itself, but incorporates terms which are set out there. And there were, with slight variations, similar problems which arose in relation to the other policies which arose, although there were some policies where there was no dispute, but there was a English exclusive jurisdiction clause. The judge discussed, first of all, the question which is to be found. The judge discussed the question of whether there was an exclusive jurisdiction in what he referred to as the Treviso policies. That was the one where there was a dispute as to the existence of the clause, starting at 345, page 79 and following. And under that heading, he first of all dealt with the question as to what proper law was that you dealt with for dealing with that, and effectively concluded that it was English law, alternatively that he didn't appear to be any difference between Italian and English law. And then he came to deal with his conclusions on the basis that English law applied at page 347, paragraphs 85 and following. And he starts off by saying, where a contract contains specifically negotiated terms and also incorporates a pre-existing set of standard or printed terms, the former will prevail over the latter to the extent of any inconsistencies. However, there are also cases which says, where possible, the court should seek to read the specifically negotiated and incorporated terms together. And he then sets those out. And then at paragraph 87, he says, elsewhere, I've suggested what might be described as a jigsaw approach to construction, under which all the pieces that are to be used, if at all possible, can sometimes risk a false equivalence between bespoke and boilerplate contractual provisions. Whatever the merits of seeking to read provisions together as a general rule of construction, it's clear that the enthusiasm with which this approach should be adopted will vary between contractual terms and contractual contexts. In Homburg-Hooting Point, the House of Lords criticised attempts to read the clear identification of the carrier as the charter on the front of a bill of lading, together with the elaborately drafted identity of carrier provisions on the back. Lord Bingham warned that to seek perfect consistency and economy of draftsmanship in a complex form of contract which has evolved over the many years is to pursue a chimera. Lord Hoffman said the courts below had been led into error because they conscientiously set about trying, as lawyers naturally would, to construe the bill of lading as a whole, whereas the reasonable reader of a bill of lading doesn't construe it as a whole. For some things, he goes no further than what it says on the front, and if that is clear enough, no attempt at reconciliation is required. Just pausing there, my lord. In order for this injunction to be granted, it has to be found, applying the conventional principles, that my client acted in breach of an exclusive jurisdiction clause in issuing proceedings in Canada. From my client's point of view, of course, he perfectly properly issued proceedings in Canada in relation to the primary, in relation to an Albertan project where there was a substantial claim made upon him. He looks at the front page of the policy and says, well, has the Albertan, there is no suggestion that that claim under the primary policy is wrong. It's from Chubb, an associate of my learned friend, Mr. Quine's client. He effectively acts for Chubb Europe. Chubb US issue the primary policy. And so you've got an umbrella sitting above it. We then issue in Canada, in relation to the primary, first excess, second excess, and the third excess. And what we say could possibly be wrong with that, it's logical, perfectly sensible to do that. It's now said that when you look at the back of the policy, or at least some of the policies, not all of them, that we're in plain breach of those provisions. And in my submission, that is a classic example of taking something which an ordinary businessman would not do. We as lawyers, of course, think, aha, well, although it's headed primary law and jurisdiction, there might be something in the conditions which might affect that. That, in my submission, is, as we would say, supported by Lord Hoffman, not the ordinary approach.
Mr. Stewart, this may be completely off the wall, but I'm wondering whether we're really talking about the contrast between specifically negotiated and standard terms at all. Aren't we really dealing with a case of incorporation of terms?
Well, that's what the judge thought.
Well, that's what the policy says. The policy, at the front of the policy, it says these conditions are incorporated.
Oh, no, I don't think I can take that point, my lord, because...
But I don't think it's a point in your favour at the moment.
Well,
so clause 12, clause 11 are in what you assert to be standard clauses, not specifically negotiated clauses. But they're in a group of conditions which have been specifically incorporated in the policy by the words at the front. Am I completely off the wall?
I hope so. I'm sorry, my lord. My submission is yes, you are. Yes, sorry. Just go. I think it's probably helpful to go back to the policy.
Yeah.
If we go back to the primary.
Well, I was in fact talking about the first and third excess at the time.
Well, I mean, it doesn't matter for present purposes. But if we go back to the first excess, which is at tab 6.
Yep.
My lord, in my submission, there can be no doubt but that the PPJC is an operative provision of the terms of the policy. And if one looks at the PPJC, on page on page 116, this doesn't need to incorporate anything to have effect.
No, but the condition, no, I'm on a slightly different point, which may be completely off the wall. If you look at page 106,
yes.
Conditions, wording is attached, incorporates the conditions, which start at page, whatever it is, of 30.
Sorry, Lord, incorporates the provision starting at which page?
Clause 12 is part of conditions which start at page 132.
Yes.
I understand those to be the wordings, the conditions that are incorporated by the phrase at 106, conditions, wordings attached.
Well, Lord, the reason why I was saying that wasn't a point that I could take is that this document, as it were, the whole of this document which you take out here, is pages 1 to 30, or as the judge laconically observes, 1 to 32 of 30 at 136, and in fact includes in this case pages 1 to 7 afterwards at 137 to 142. So this document, in a sense, is the document which is the contract. It doesn't require to be looked at for any other purposes, and that was why I was saying that it was a point that I couldn't take. In other words, I can't say that this only it's the equivalent to saying that the terms of the Italian conditions that we were just looking at are set out in the policy itself.
All right, so is it your submission that the principles that apply where contract terms are incorporated, as between the incorporating and the incorporated conditions, are of no relevance in this case?
Yes, I say they are of no relevance, and the point I'm on at the moment is that if you've got, for these purposes, what I say is a specifically negotiated term at the front.
I understand that's the point that you're pushing at the moment, which is why I raised what may be a thoroughly bad point as and when I did.
Well, my Lord, just to be, the only reason I'm hesitating is I want to be, just to be clear that there is no misunderstanding. The parties have proceeded throughout on the basis that each of the policies in this case, in terms of the contract documents which was stamped by the insurers and then issued to the insured, is the entirety of what you get within tabs 6, 7 and 8 respectively. This isn't one of these cases where there's a document which you then have to look at the Italian terms for.
Could I understand a bit more clarity what you're saying about the distinction here? Firstly, as far as front and back is concerned, there's no front and back issue here, is there? It's not a classic case where you have.
It's not literally the bill of lading on the front and the conditions on the back as you used to get to photocopy a contract.
Yes. So I'm trying to understand why it is that you say there is some similar distinction here. Because may I just ask? Because I can't see anything on the face of this which demonstrates that the clause at 116, choice of law jurisdiction, has been specifically negotiated any more than clause 12. Now, maybe you say to me there's some evidence that is the case, but I haven't seen it. And there's nothing in the scope of the. It seems to me that the contract is structured as you go through it. And in this one, you haven't even got the extremely good point that it's in smaller typeface. And so why do you say there's a difference in the degree, intensity of negotiation for some clauses rather than the others?
My Lord, if your Lordship would be kind enough just to look at the judge's judgment in relation to this. And
Are we coming back to Mr. Justice Foxton, or are we finished with him?
I was going to come back to Mr.
Right.
Justice Foxton.
Completely away. Thank you.
The judge says two things. One, he says it's specifically negotiated, and two, he says it's a standard term in two different places.
Yes. Well, he says he suspects it may have been a standard term on these, but I was actually on a slightly different point. Well, if I could just queue up the questions to answer them in order, you'll see that one thing the judge does do is to identify the history of how it is that one got these clauses in the form they're in. And if one looks at paragraph 50 on, start at 49.
What page?
66, Mike. And what you'll see is him saying each of the four policies began with a number of pages which started with the heading risk details. The background to form these policies is described in Merkin, etc. And he then identifies that prior to the reforms between 2004, the typical procedure was for slips, etc. And then, however, in many cases there was no policy wording in existence at the time when the contract came into effect, which Merkin described as one of the weaknesses in the system. And then what is set out is, following intermediate reforms, the FSA challenged the market to come up. And this work resulted in the market reform contract. And just for me there, this is such a market reform contract, or these are such market reform contracts, which is now the standardised form of agreement. There's no longer any reference to the slip. Instead, as Merkin describes, the presentation consists of an introductory section setting out the most important details of the slip, which more or less corresponds to the old slip. But attached to this document is a schedule which sets out the terms of the policy. The effect, therefore, is that all the documents are prepared up front, and when the underwriters scratch the documents, the contract is in its entire form. And then the market reform contract must include the details set out in the published guidance. It includes a series of sections, including risk details. The risk details include, for example, the Unite market reference, the type of policy, the interest insured, the monetary limits, and the choice of law and jurisdiction. So all of what you see under, as it were, the left-hand things are required as being forms of the contract. And the analogy which I'm drawing here is that that is equivalent to the important terms which are required to be put on the front of a document as compared with the conditions which might...
So the contrast is not so much between specifically negotiated and standard terms, but between important terms and less important terms.
Well, my lord, I'm seeking to make both, but on this, I'm on more important and less important, which is, I say, the equivalent of front and back. The specifically negotiated, as opposed to the specifically negotiated as opposed to the general, is because in my submission it is impossible to go through all of the headings under the risk details where one sees the individual terms with periods from the 31st of January 2015 and so forth, and particular points being put in, as compared with what in my submission are plainly sets of standard terms and conditions. And the reason I said that way, sets of standard terms and conditions, is that I showed you they include provisions which are not applicable to this particular point. So I am seeking to make both points.
Well, I can see that some of the risk details are necessarily specifically negotiated because they're the kind of policy that the insured wants to have. But others may or may not be the subject of any actual negotiation. They're just the terms put forward which might be accepted without discussion, worldwide, including USA and Canada. Marsh say this is what the client wants and the insurers agree it, and there might not be any negotiation about it. So I'm not quite sure what you mean by specifically negotiated, if you're saying that that necessarily applies to all of the risk details clauses.
I mean, my lord, there are plainly degrees in relation to this. Can I put it this way? Someone has to decide what to put under each of the heads of these mandated headings, one of which is law and jurisdiction. That someone has made it plain that law and jurisdiction shall be the same as the primary. The primary is specifically referred to in all of these policies immediately before, in the block before. That is to be contrasted with a set of terms and conditions numbered from 1 to whatever they are at the back, which are plainly not specifically negotiated. Now, my lord, in my submission, when you stand back and say, well, what are you trying to do here? We're trying to understand what the reasonable readers of this contract would understand from it. But my learned friends have to say the reasonable readers of this contract would understand that the only place that they could bring proceedings would be England. That's what they've got to understand. The point I'm making is that a reasonable reader of these contracts, when he gets to the primary jurisdiction, or the PPJC, will say, well, if I'm interested, I have to look at the primary, but otherwise what I can see is that everyone in this tower, with the exception of Allied World, who've scratched their way out of it, has agreed to the same terms as the primary. And
then you look at the primary to see what the terms were.
well, no, Miller, why do you need to do that? That
You might be interested to know where the jurisdiction is.
well, as you might as a lawyer, my clients, and quite possibly the insurers, may simply want to know that they're not put to the trouble and expense of having multiple things. That is with respect to make the very mistake the judge made, which is to assume that parties value knowledge as to what the law and jurisdiction is more than having all of these disputes in one place.
Well, what we know is that the insurers, if they are indeed standard terms, have as provided that each and every one of their policies will be subject to the exclusive jurisdiction of the...
With the exception of the second excess.
Yes. English law and jurisdiction. And then surely what one does then is say, yes, but obviously it's subject to specific agreement otherwise.
That's
so one looks at the, you would say, specifically negotiated terms to see whether or not they have provided otherwise.
No, but that's the very mistake that the judge made. That's starting at the back of this policy.
Well, this is the key point in your argument, isn't it? Whether the judge...
Well, it's an important point. But my lord, why on earth do you do that? Why does a rational businessman start reading this policy from the back and say, well, is there something...
No, you read it all together.
Well,
you read it all together and you can see in there that there are two jurisdiction clauses on the face of it. And you can see that one of them is an exclusive jurisdiction clause, which you think, right, that's what, as you say, seems to be the standard provision. Let's look at the other one to see what that says. And when you look at it, and you see that it doesn't provide for anything different.
Well, my lord, with respect, it does. That's my point with respect about where the judge has gone wrong. If you look at the terms of each and every one of these, the operative provisions of this policy of the PPJC finish at the point at which it is said any dispute concerning etc. understood and agreed to be subject to the same law and jurisdiction as the primary policy.
Does your submission really come to something like this, that the reasonable reader knows that it is mandatory in this contract form to have a law and jurisdiction clause up front in the risk details? So if he wants to know what the chosen law and jurisdiction is, that's where he looks. And having found it, he doesn't scour the policy to see if there is some other clause somewhere else.
That is certainly one way of putting it.
And would your submission therefore be exactly the same, even if the clause buried in the terms and conditions said, notwithstanding what it says up front in the risk details, English law and exclusive jurisdiction?
Yes, my lord, it would. One can take this in stages.
So that's not really that's really Lord Hoffman. You look at the front, not the back, transposed into this situation.
The reason I'm hesitating about agreeing too readily with any one single proposition of what my case is that it's part of the case. I say that the overall question your lordships have to decide is whether you can be satisfied on a reading of the policy as a whole that my clients have promised not to bring proceedings anywhere other than England. That's the question. So, and if they haven't done anything wrong.
I think we understand the concept of an exclusive jurisdiction clause and an anti-suit injunction and breach of it.
Yes.
And what we're trying to work out is whether or not, on a proper construction, that is the case. Right.
My lord, yes, but when your lordship says that you, as it were, look and see at the clause at the back of the policy which sees anything which derogates it from it, it suffers from the following defects. One, as my Lord Justice Mayle says, that's not where the reasonable businessman would start. The reason he knows...
Stuart, the rational businessman reads the whole policy.
Well, my lord, that with respect is, I mean, I'll take you back to look at the whole bills of lading. That is disagreed with by what.
Well, that may be true of bills of lading. Speaking for myself, I do not accept that it's a rational approach to contracting on a multi-million pound policy not to read the whole policy.
Well, my lord, the question that one is seeking to do here, if I may say so, is to identify what is to be done about a clause which has got operative provisions
That I accept.
which are different from those which are at the back. And there are a number of different possibilities. I mean, I shall suggest when I get to it that in respect of the first excess layer, you can actually read them together by saying shall is not mandatory and it's not perfect, and it might in other contexts means different things. But that's the first thing you do about it. I for present purposes, as it were, I'm on the, sorry, I give you the wrong policy. The umbrella has got the Scottish provision, the first and third have got the clause which I accept and have always accepted is as it were, incompatible with what's put forward. But my lord, there are problems with both. The reason I'm challenging Lord Justice Phillips' formulation of the case which he was putting to me was that anyone in my submission looking at the PPJC and thinking, well, what's important to us? Well, what's really important to us is that we don't get some nightmare whereby we have different courts looking at different aspects of this. And
look at it the other way around. I mean, it's accepted. Say, okay, that's everyone's going to focus first on the PPJC at the front, specific negotiated. We look at that and we read it. Does it tell us which jurisdiction applies? You read through it and you say, no, it doesn't. Say it says it should be the same as other policies. That's the starting point. We then look through the rest of the contract and we see that, lo and behold, there is a clause there which we take it is the insurer's standard provision, which says that there should be exclusive English jurisdiction. So that's the question then, where does that leave us? I'm not sure it really matters which end you start on. You come to the position, if you've got two clauses, one doesn't actually specify what jurisdiction applies, and if you look at the underlying policies, they make no provision for which jurisdiction, so it could be London, for all we know. And then we look at the express provision, subject later in the contract, which says exclusive English jurisdiction. And that's the conundrum, that's the construction conundrum that we're in.
No, but Lord, with respect, what your lordship is doing is undervaluing the other important purpose of the PPJC, which is not to tell you that it is Spain or whoever it is. It's the fact that it's the same as the primary. That's what matters. And your lordship is assuming one commercial purpose, knowing what the law is different from another one.
The difficulty is if there's no jurisdiction clause in the underlying contracts, then there may be many jurisdictions.
So what? That may be entirely desirable from the point of view of a case where, as this one, you've got a worldwide jurisdiction clause where my clients may get sued in a whole variety of different jurisdictions. But what they do want is that the disputes shall be determined in the same place. And if you look at that, sorry,
you won't achieve that, will you, on your analysis?
I'm sorry, Mother.
You won't achieve that.
Well, I will, with respect. If you look, that's why I was emphasising.
Yeah.
That was why I was emphasising the three parts of the PPJC.
Yes.
First part, your lordship has been focused on, same law and jurisdiction as the primary policy. The second clause, each party agrees to submit to the jurisdiction of any court of competent jurisdiction within said territory and to comply with all requirements necessary to give such court jurisdiction. That is the insurers promising that they won't come and challenge the jurisdiction of the Court of Alberta. That's a positive promise. And that's got real value to my clients. And the same is...
But forgive me, An agreement not to challenge a jurisdiction is different than an agreement as to what jurisdiction governs the dispute.
But that doesn't mean that it's not valuable, my lord. That's with respect why I say that you're making a mistake.
I'm having real trouble with this, Mr. Stewart, on a very, very simple basis, so perhaps you can just put me right. You agree that the underlying policy doesn't tell you where the jurisdiction is. So how can that be of any advantage to people who actually want to know what the jurisdiction of the excess policies is?
My lord, that is looking at only one purpose, and that's the point I
I don't understand the other purpose. I mean, I've heard you say that the purpose is to know that it's the same jurisdiction as the underlying policy. But then I've also heard you say that we don't know what the underlying policy's jurisdiction is. So how can that be an advantage to anybody?
Well, because, Mike, what it means, that's why I was going on to the second part, which is each party, let's suppose, for these purposes, a valid proposition, that the first part says any dispute concerning the interpretation of the terms, conditions, limitations, exceptional conclusions are understood and agreed by both the insured and the insurers to be subject to the jurisdiction of any court in which my clients operate. Let's suppose that's what it says. In other words, it doesn't tell you who's the jurisdiction. And then you get each party agrees to submit to the jurisdiction of any court of competent jurisdiction within said territory and comply with all requirements necessary to give such court jurisdiction.
But that means, as I understand it, you wouldn't dispute that notwithstanding that proceedings have been started in Alberta, that the insurers could commence proceedings here seeking a declaration of non-liability.
No, but what they can't do is challenge the jurisdiction in Alberta. And sorry, Model. Sorry. No, but at that point, one would then come into the question, which is where one goes back to comity and looks at AMCM, which I do want to go back to, of saying, well, what would the proper course to be in relation to that? The answer is to decide who would be best placed to deal with this dispute.
This is putting the cart before the horse, isn't it? Because what we're looking at with these jurisdiction clauses is the party's choice of jurisdiction, not whether they have agreed that they can't obtain anti-suit injunctions.
But, my lord, the second is a prerequisite to the first.
My understanding of your powerful submission is that the important thing here is that all of these disputes throughout the tower, with a certain extent, should be in the same jurisdiction. But your construction here doesn't achieve that. It doesn't stop parties commencing proceedings in any number of different jurisdictions. All it does on your case is stop them seeking anti-suit injunctions against people starting cases in other jurisdictions.
My lord, the way I would put it is this. Suppose, for present purposes, that which I am putting forward is correct, namely that on a proper construction of these policies, there is no English exclusive jurisdiction clause because it conflicts with this provision which is here. Let's suppose that's the case. Now suppose that we did what we did previously, which was we issued against all of the various insurers, and we did what we would no doubt have done but for the existence of the injunction, because we didn't particularly fancy coming before your lordships, starting off with an application to be excused from contempt, which is that we didn't serve anyone other than that party which we were entitled to continue against, namely the primary insurers. In other words, let's suppose that in Canada we had proceeded with all of the original parties, namely the primary, the umbrella, first, second and third excesses. Now, of course, the insurers could have come to London and said they're seeking a declaration, but would the London court in those circumstances have said, oh, well, we're going to grant you an injunction in those circumstances? Or would they say, well, what have you done in Canada? Have you sought a say? Have you explained why it is that you said that your dispute shouldn't be settled there, and so on and so forth? And my lord, that, in my submission, given that you've got the operative provision, which is that they agree to submit to the jurisdiction of any court of competent jurisdiction, is a valuable benefit to my clients. No sane commercial court judge in this country is going to start off with the proposition that it was a good idea to have multiple proceedings where a party's already been sued in Canada. I departed a few minutes ago from Mr. Justice Foxton when my Lord Justice Males said, "Have we finished with Lord Justice Foxton?" And I said, "Not quite." But it's possible that I've left out one of the questions in my Lordship's list, and if I have, I've forgotten it. But subject to that, I'll go back to Lord Justice Foxton, if I may. My Lord, we got to page 348. And I can't now remember, I'm afraid, whether I've taken you to 89, but 89 might, in my submission, provide some help to Lord Justice Stuart-Smith in relation to the question which he asked me right at the beginning, which is what's a bespoke provision? Because what he says is that the jurisdiction condition is a bespoke provision specifically agreed for the provider policies, and it's set out in terms on the face of the cover notes. By contrast, Article 3 is a printed term and a standard set of conditions, while the set of terms is specifically referred to in the contractual documentation, Article 3 is not. Well, of course, the second part of that does not apply to me. The first part in my submission does. And then, going on, second, the way in which the contractual wording refers to each provision itself suggests the jurisdiction condition is intended to have a higher contractual status, rather than to be commensurate with Article 3. Jurisdiction condition is described clearly what is used clearly a promissory language, a condition, etc. Now, my Lord, I can't take much from this because they're both referred to as conditions. But then over the page at 91, I do seek to take support from what is said in 91. The contractual documentation in this case, like the bill of lading in the Starsin, is of a type in which the parties would ordinarily look at the matters expressly set out in the primary contractual document, in many insurance cases the slip, here the generalities cover notes, to identify the key contractual visions, and they'd not expect to have to look in printed terms incorporated by reference to ascertain the meaning and effect of those key contractual provisions. Now again, and in my submission I've got half a loaf in relation to 91. They're there, but what are the key provisions? Why was the provisions put forward? Well, the answer was to put it at the front.
Taking together the two half loaves that you get from those paragraphs, does your submission really come to saying that what we get from this is that the form of the contract may indicate that some conditions have a higher status than others?
Your Lordship, yes, I accept that. Yes, I do. Well, we then get to the point which I do rely on in 93. The construction of which Mr. Davey contends should be given to the jurisdiction condition, when read in conjunction with Article 3, would involve two different courts having jurisdiction, the possibility of different insureds or the insureds commencing proceedings in different jurisdiction with respect to the same casualty, even though the other insurers had agreed to follow Generali's claims lead. Now, that brings me directly back to the points I was making to Lord Justice Phillips. And in my submission, once you've agreed that you will submit to the jurisdiction of a court in the PPJC, it would not, in my submission, be open to you to come along with any realistic hope of success and take proceedings in London for a declaration. We would say, well, the dispute's taking place in Canada, there's nothing the matter with it taking place in Canada, and you've agreed to submit to the jurisdiction there. And there are good reasons why it should all be determined in one forum. Look, at that point, I'd like to look at AMChem, if I may. Now,
can I just understand this, though? As I understand it, if the insurers had got in first and issued proceedings in London seeking a declaration of non-liability, it would all then have been determined in London.
Yes, and what's the matter with that, my Lord?
Well, I'm asking the question. You just agree with that?
No, sorry, but well, yes, and rhetorically, What's
wrong with that?
What's wrong with
Well,
that?
I mean, if that's the case, then rather suggests that, again, if your interpretation of the PP, do you call it JC, is such, then is it then surprising that the insurers have specified an exclusive jurisdiction in London when you don't dispute that they could effectively obtain that by commencing proceedings here anyway?
But my lord, that with respect undervalues the two aspects which are in my submission of importance. One is that the dispute be determined in the same form. Secondly, and the number of occasions when insurers seek negative declarations is pretty small. It gives my clients the opportunity to say, well, look, this dispute is now going on. We're being sued for more than 250 million Canadian dollars. Insurers aren't on our case responding appropriately. We want to bring them all in an action in Alberta. We look at the PPGC and we do so. My lord, I was going to take you to AMCAM. You'll find AMCAM at tab 16 of the, if you're working in hard copies, the second authorities bundle. Starting at page 506 of the PDF, I hope. Yes. And this is a 1993 decision of the Supreme Court of Canada. There's a sole judgment which is given by the court, and it's dealing with considerations where what had happened was that there were 194 plaintiffs who had suffered injury said to be caused by exposure to asbestos. I suspect at least one member of this court will be finding some of this familiar. And the respondents, the defendants, were incorporated, most of them, in the United States of America. And although they didn't carry on business there, most of them, although they weren't incorporated there, most of them carried on business there. You see that from the second paragraph of the head note on page 507. And what happened was that the Texas court found jurisdiction and venue. The asbestos companies applied to the Supreme Court of British Columbia for anti-suit injunctions against the appellants in order to prevent the continuation of the Texas action. And the Texas court issued an anti-suit injunction prohibiting the seeking of injunctions in Canada. And when one then looks at what the court said, one sees in the head note, which accurately records what Mr. Justice Spasinka said, 508, courts have developed two forms of remedy to control the party's choice of forum. First, a more conventional device is a stay of proceedings. It enables the court of the forum selected by the plaintiff to stay the action at the request of the defendant and persuaded the court should be tried elsewhere. The second is the anti-suit injunction, which may be granted by the domestic court at the request of the defendant actual potential. With the stay, the domestic court determines for itself whether in circumstances it should take jurisdiction, whereas with the injunction it in effect determines the matter for the foreign court. While the restraining order operates in personam on the plaintiff in the foreign suit and not on the foreign court itself, it has the latter effect and therefore raises serious issues of comity. The court should entertain an application for an anti-suit injunction only where a serious injustice will occur because of the failure of the foreign court to decline jurisdiction, arriving at the forum non-conveniens effect. And when one sees the judge's actually just going over the page in the head note at 900. The domestic court should not entertain an application for injunction if there is no foreign proceeding pending. An injunction, generally a remedy ancillary to a cause of action. The antecedent injunction is unique in that the applicant doesn't have to establish the assumption of jurisdiction by the foreign court will amount to an actionable wrong. And then deals with
That's not English law, is it?
No.
Well,
Yes.
no, my lord. And as when we get to it, we'll see that this is in the context of what's being put forward, of there being no express agreement in relation to matters. In other words, it's general matters. The reason I'm citing it is twofold. One is to identify the fact that when one talks about comity, other countries look at this different from the way that the English law does, although the English law does say that you need to be careful about it.
Well, you don't have to go to Canada for that. You can go as near as Luxembourg.
Well, yes, although in some ways we may be further from Luxembourg than we are from Canada now, although I was reminded when at first instance I was criticising the fact that a lawyer from Toronto was giving evidence as to the law of Alberta, and it was pointed out to me that Alberta, or more accurately Edmonton, is quite a lot further from Toronto than London is from Moscow. But anyway, but the second reason that I'm just dealing with this is that when one looks at my Lord Justice Phillips's point as to what happens if you don't have an exclusive jurisdiction clause, there are well-established criteria which are internationally recognised as to how one goes about it. In other words, it isn't some form of problem or disaster, if I can put it that way. What I would submit is that to have a regime whereby you can have, as it were, proceedings starting in one place, we would say entirely legitimately, then being enjoined so far as part of those proceedings are concerned, with proceedings taking place in other words, would not be a result which rational businessmen would be likely to entertain with equanimity.
Well, that's undoubtedly right, but then it can arise where you have parties have expressly agreed by exclusive jurisdiction clauses or arbitration clauses that they will determine their particular part of a dispute in a particular jurisdiction. It's a matter of whether that's agreed or not. And I can also see that when determining whether or not they have so agreed, one may bear in mind the factor that you indicate. But ultimately, the court has to decide what the parties have agreed, doesn't it? And that's all. That's the be all and end of it.
With the sole exception of the last, I think, 7 words, I agree with your lordship about the three antecedent propositions. Can I just draw attention to the passages that I wanted specifically to draw attention to?
Yes.
The first is on page 913. Which is reminding us, those of us of a certain age, in the middle paragraph on the left-hand side, the point which I said, well, you don't need, my Lord Justice Mel say you don't need to go to Luxembourg. Any doubts that a foreign court will not regard this as a breach of comity are dispelled by reading the reaction of Mr. Justice Wilkie of the District of Columbia, the United States Federal Court of Appeal in Laker Airways, in which the British courts restrained Laker from continuing an anti-suit injunction in the United States courts against British Airlines. In assessing the role of comity in the formulation of principles which should informally exercise its power, I adopt the definition of comity approved by La Forest J. in Morgard. And then this, comity in the legal sense is neither a matter of absolute obligation on the one hand, nor of mere courtesy and goodwill on the other, but it's the recognition which one nation allows within its territory of the legislative, executive or judicial acts of another nation, having due regard both to international duty and convention, and to the rights of its own citizens or of other persons who are under the protection of its laws. And then just in the middle of the next paragraph, after citing from the article by Mr. Rauskenbush, a case can be made for this position. In a world where comity was universally respected and the courts of countries which were the potential fora for litigation applied consistent principles with respect to the stay of proceedings, anti-suit injunctions would not be necessary. A court which qualified as the appropriate forum for the action would not find it necessary to enjoy similar proceedings in a foreign jurisdiction. And then he goes on to say, well, the above scenario is one which we would strive to obtain. It is not one that has yet been achieved. And then, last passage, in some cases, a serious injustice will be occasioned as a result of the failure of a foreign court to decline jurisdiction. It's only in such circumstances the court should entertain an application for an anti-suit injunction. And well, why does one look at that? Well, one looks at it because one is starting from the proposition that one is looking for here what my learned friends have to establish, in my submission, is a clear agreement which we have broken. On the face of the PPJC, not only have we not done that, but they have. That gives rise to a very serious issue as to which is right. There are two purposes which are being served in my submission by the PPJC. One is to ensure that all disputes are litigated, subject only to express derogation in the case of Allied World, in the same place. That is unaffected where that place is. The second is to say, well, you have to look at that, the primary policy, to decide which law and jurisdiction governs. Both of those are inconsistent with the terms of the clauses at 11 and 12. The policy is telling you to do two different things. My lords, in my submission, where there is a dispute as to whether someone has or has not promised to do something in a policy, and you can't decide whether they have or not, you say, well, they haven't promised to do something which is not clear because of ordinary contractual principles. Does that give rise to any injustice in this case? No. Does it give rise to commercial good sense in the course of this case? In my submission, yes, because you're going to have everything determined in the same place.
But you could sue each and every one of these insurers in a different jurisdiction, couldn't you?
Well, my lord, that comes back to the meaning of the PPJC. Each party agrees to submit to the jurisdiction of any court of competent jurisdiction within the same territory. My lord, in my submission, applying a sensible, there are 2 points. That would be a pretty extraordinary thing for us to do. I mean, why?
No, but you say it's a worldwide jurisdiction. It provides for worldwide jurisdiction. That's the words you've used.
What I hope I've said is that the primary policy doesn't contain any express choice of law clause or anything else, that it therefore will be governed by ordinary jurisdiction principles. In order to be able to sue in a relevant court, you will therefore have to have a close and real link with the relevant country. That will be a wide variety of different places. I don't
you might
think
take the view that you sue each insurer in their own country.
My lord, well, my submission, that would be odd given the whole language of be subject to the same law and same jurisdiction as the primary policy. This looks as if what it is saying is you're going to have the same single jurisdiction provision. But secondly, my lord, and therefore it's pretty unlikely that we're going to do it. If necessary, one could imagine it being said, well, we're only agreeing to do this once. We're not doing this on numerous occasions.
But the irony of it is that in fact, accepting the English jurisdiction clause, with the exception of the second excess, would ensure your great goal of having everything tried in the same place, whereas your construction wouldn't necessarily achieve that. They could all be tried in different jurisdictions.
Well, just focusing on that, the starting point is that what that would involve doing is saying that where you have a dispute in Canada, where the underlying facts, documents and so forth are in Canada, and where the underlying facts and so forth are all in Canada with the witnesses and everything there, we have to come to London to have this dispute decided, even though there is no clause in the primary policy which requires us to do so. That would not be an ordinary thing to expect to have to happen. That's if we want to have the whole thing decided in one place. By contrast, if we're right, then we, as a valuable, as it were, part of what we legitimately want to do, can say, well, if insurers have agreed to submit to jurisdiction anywhere, this is a Canadian... No one suggested that we have been in any way willful or unreasonable in suing the primary insurers in Canada, where the position arises. In those circumstances, we then say, well, we've got a policy which says on the front, we'll submit to the same law and jurisdiction, we want that there. That's a pretty rational thing for us to do. It would become rather odd, especially when, as your lordship observes, the second excess is the odd man out, to require us to do something else.
Did you say you've got the global policy here? The global underlying policy?
Yes, I did. Could we... it looks like this. We've got three policies here, but can I just identify what they are?
Please. Thank you so much.
Thank you.
314, the underlying policies, pages 2 to 143.
Yes. So the first policy is AIG USA, which is the sister company of the issuer of the global umbrella policy, which runs from 202 through until 143.
And who subscribes to that?
The subscribers are to be found on. I think it's just ACE. It's just Chubb. Yes, it's just ACE. And for these purposes, it covers a large number of different forms of liability policy. Can I just identify the other two so you understand how, as it were, they fit together? And for almost all purposes, not quite all, but for almost all policies, it is covering liabilities everywhere in the world except the United States. The second policy is to be found at 144 and following. And what this does is the broadly equivalent policy, which is covering United States risks. And if you start looking at page 148, you'll see a whole series of provisions which are dealing with, at 148, the Colorado fraud statement, 151, the Georgia notice, 153, the important information to Virginia policyholders regarding your insurance, and so on and so forth. And I can't now remember whether this is only United States, but certainly it is predominantly the United States. And just for completeness, the third policy is what's been referred to as the Beasley Policy. This policy on the evidence before the judge is actually paying us something. One of the issues is the interrelationship with this policy and the other two policies at 346. It's a different form of policy. It has an express New York choice of law clause at page 348.
But so far as we're concerned, tab 1 is the underlying policy, and it's issued by ACE America, who are the Marsh USA, so obvious connection with the United States.
I'm sorry,
obvious connection with the United States.
Yes.
So just picking up on what my Lord Justice Phillips said, and not reaching any decision about it, but there's an implication that, for example, this might give jurisdiction to whichever state of the United States is a relevant place of business or anything like that.
My Lord, I would accept that it could well give jurisdiction to a number of places, including, I mean, the answer, the issue possibly in that case would be that it's territorial scope, but I'm not going to start argue. I mean, it plainly gives jurisdiction, which will depend probably on where the policy was written, to a number of different places. Sorry, where the underlying liability arises to a number of different places, which I suspect, for both your and my purposes, is sufficient for present purposes.
And this is 2 million in excess of 2 million.
Sorry, which one, my lord?
The one we're looking at.
Beasley's 10. Yes.
I was looking at the diagram.
Yes, my lord. The only reason there is a dispute.
There's a dispute about whether there is a retention. Yes. So it's perfectly possible that the primary policy would simply pay out because it's perfectly clear that there's, its cover is going to be exceeded, and it simply pays. But there's a dispute under the higher levels because they may or may not be reached. How does the PPJC work then? There's no litigation under the primary policy. That's one of the points which the judge made, which you've not addressed yet.
No, my lord. I mean, two points in relation to that. All that has happened. Sorry, just to be clear, I'm sure your lordships have got it. But in terms of the factual background to this, we issued the evidence was we issued but did not serve at the time of the proceedings before the judge proceedings against the primary under this policy, which you've just seen, together with all the ones which are, as it were, and have always been in front of you. We've now served within the 12-month period of the... And sorry, the evidence as to why we did that was that we were concerned about limitation. We have not served the other above the primary. Something else would have been in breach of the injunction for doing so. My lord, I can't give evidence to you as to what the course is. All one would say, I think, is this. It might well be that there are specific Canadian statutes.
No, I wasn't really asking about the facts of this case. I was simply taking a hypothetical case where it looks as if there's an insurance claim and you go to the primary. You go to the primary insurers and they say, you don't need to sue us, we'll pay. Insurers do sometimes pay without being sued.
Yes, my lord. Well, just so far as that is concerned, that happy experience, which I agree does occasionally happen, it isn't the case in relation to the primary. The point that was one of the reasons I wanted to say.
I understand it's not the facts of our case, but
in a hypothetical world, they could say,
how do you decide?
We've only got £2 million. Well, my lord, the answer.
So how do you decide the application of the primary policy jurisdiction clause when there is no jurisdiction anywhere because the primary insurers have simply paid?
Well, my lord, if one looks at the operative words of the provision and leaving out for these purposes clauses 11 and 12, my submission is no real difficulty. Any dispute concerning the interpretation, etc., understood and agreed by both to be subject to the same law and the same jurisdiction as the primary policy. Now, so far as the law is concerned, my lord, simply because there isn't a present stated law doesn't mean there isn't a law of the primary policy. So far as the jurisdiction is concerned...
I would find this submission much easier to understand if I understood what it was being said that the law of the primary policy was. And I've asked about 3 times, and I don't think I've had anything approaching an answer. It may be that my question's irrelevant, but at the moment, I have this problem. We go drilling down at your behest of the primary policy, and then we have nothing.
Well, my lord, I'm sorry that your lordship feels that I've been dodging the question. There isn't an express choice of law clause in the primary policy. That does not mean, and it's a point we make in our skeleton argument, that whether under the convention or otherwise, there is not a proper law of the primary policy.
Has any attention been given to what that proper law might be?
Well, my lord, we have not put forward a positive case as to what the proper law should be. But, my lord, with
Except it includes Alberta.
Well, actually, not necessarily. In Alberta, as in England, if no one makes a case as to what the proper law should be, one's going to proceed upon the basis that it's the law of England or Alberta, as the case may be. But if someone wants to make a case that the proper law of the primary policy is some other place, well, they can no doubt do so. Lord, it comes back to a point which lawyers sometimes think that choice of law and jurisdiction clauses matter more than businessmen think that they matter.
Well, judging from the volume of litigation we get about that subject, businessmen seem to think it matters as well.
Well, they think it matters once, but only once. They've been to lawyers about a potential dispute.
Anyway, you've answered the first part of my question. You say there's still a law, even
and so far as
there must be one.
Right.
So what do you say about jurisdiction?
And so far as jurisdiction, same jurisdiction as the primary policy. My Lord, again, just because the primary policy doesn't contain an express jurisdiction clause doesn't mean that there is nowhere that you can sue.
But I thought your case was that the effect of the clause isn't effectively to confer jurisdiction, but to prevent you challenging jurisdiction.
Quite. In other words, there are likely to be multiple places where you will have jurisdiction under a policy such as that which I've now handed up to your lordships.
So in a case where there is no actual litigation under the primary policy, your case is that the PPGAC means that there is jurisdiction in any place where one or other party could have sued under the primary policy.
Yes, my lord. Which will be a large number of places.
Yeah.
What do you say worldwide?
Well, the only reason I gave as an example worldwide, I mean, if it is possible to imagine situations where it would not be possible to have a legitimate connection with the policy, but for present purposes, it probably doesn't matter.
Yes. Well, what you're saying, as I said, what you're saying is the effect of that clause, incorporating it into these policies by reference to the underlying policies, is not to provide for any specific jurisdictional basis, but simply to say you can't challenge any other jurisdiction.
So, subject to your lordship's word incorporation, yes. And your lordship, I think, knows why I say incorporation. This is equivalent to say to be subject to the same law and same jurisdiction as Lord Justice Stuart-Smith chooses. In other words, it's a reference to an alternative matter. It's not incorporation. And well, I think I would submit your lordships have probably got the difference that I take between incorporation, which is the equivalent to the generality of whatever it was, the Italian conditions, and these words, which are operative words, but refer to something else. And as I say, you can replace as the primary policy with as is set out on the tombstone at number 474 Garrett Drive. They're not incorporation, they're just telling you what you have to do in order to operate the operative words.
So if the one or other party asks the broker, looking at the PPJC, so what's the jurisdiction clause? What's the jurisdiction I'm agreeing to here? The answer would be, well, actually it could be anywhere in the world.
In practical terms, that's likely to be the answer that you'd be likely to give, yes.
Okay.
I mean, the quibble is that possibly that wouldn't be an entirely accurate answer because there might be some places that you couldn't sue. But if from a practical point of view, yes, it's likely to be a large number of jurisdictions.
Yeah.
Which I think comes to the same answer, yes, practical answer.
Yeah.
Right.
Lord, we're getting through my points.
Well, you're getting a certain amount of flack, but I'm sure you're making them all as you go.
I'm trying to. My Lord, could we... Sorry. Yes. Could I just go specifically to the judge's judgment, please, and make some specific points of criticism in relation to the judgment? and you've got what the judge described. Now, the way that the judge went around dealing with the matter was to start dealing with the global umbrella at page 69 of the matter. And he did start with the propositions at 62, which is that Chubb submitted that Clause 11 was an exclusive jurisdiction court in favour of the Commercial Court in London, and then set out my submissions in the order policy issued in Scotland. If wrong, the clause should be construed as a non-exclusive jurisdiction clause, and that it didn't displace the PPGC contained in the risk details. Now, I'm sure it was my fault, but certainly I had intended my primary submission always to be the PPJC, which is what I've been concentrating on up to now, and the conflict with the points at the back. The judge goes on to deal with issued in Scotland, which I will come back to very briefly at the end of my submissions. But after dealing with issued in Scotland, he then went on at 73 to the non-exclusive jurisdiction clause. Now, as we're dealing with non-exclusive jurisdiction, the great merit so far as the global umbrella is concerned, but not, of course, the first or the third excess, is that you can actually read together the PPJC and the clause in Clause 11 of the umbrella. Because what you say it shows is that the commercial court has got jurisdiction, or the Scottish court has got jurisdiction, but it is a non-exclusive jurisdiction clause. So far, therefore, as the umbrella clause is concerned itself, it does give the benefits of insurers knowing that if they want to, they can sue in London. And as Mr. Justice Christopher Clark dealt with or set out, there are benefits to a non-exclusive jurisdiction clause. But for present purposes, and looking only at the umbrella provisions, the attraction is, of course, that you read the terms of policy and you don't disregard them. The problems my learned friends have, however, either on that case or anything else, is what do the words in the PPGAC mean? Their case has to be that they're simply to be disregarded. But these business people, insurers and insured, write this in, and they don't mean anything. Now, no doubt, conscious of the difficulties of that position in the first instance, Mr. Story was trying to say that for primary, you read global umbrella, which even for a man of Mr. Scory's ability was a difficult submission, but anyone isn't maintained on appeal. For present purposes, primary means primary, as referred to in the policy documents. And so the immediate problem that you have got, if you take the view that the clause 11 or 12 predominates, is that you give no effect to the words which are set out in the PBJC. And, my Lord, the great attraction in my submission, and I will come back, if I may, after the short adjournment, very briefly to Mr. Justice Clark's judgment. The great attraction from the point of view of the umbrella of the non-exclusive is you can at least read them together. And that,
it's a bit hard, isn't it, to read the PPJC as non-exclusive. It says all matters shall be determined in accordance with the law and practice of such court, which is primary policy court. So if that if the practice of that court has to apply, it's a bit hard to see any role for the commercial court in London.
Well, my lord, if you say we've agreed to law and practice in the primary in one part, and we've agreed in another part the law and practice or the jurisdiction of the commercial court, it's in my submission not too difficult to say, well, you've agreed to both. That would be how I'd put that point.
How does your non-fragmentation point fit in with this?
My lord, so far as on Scotland, well, it's
No,
still
on the PBJC, where I think you're accepting there are large numbers of places where they could sue and be sued.
Yes, Lord, I think I've answered that in answer to a question to Lord Justice Phillips earlier on, which is that from a practical point of view, you choose one, and that's what's likely to happen. You go there, and then, as it were, you get everything determined there. I haven't got a better or different answer.
No, I think that's right.
My lord, can I then get to the argument which we're on with the judge, which is at 84 and following and 73? And Mr. Justice Jacobs does say, the defendant's primary case that was clause 11 in the standard terms should in effect be disregarded because it conflicted with the PPAG which appeared not only in the global umbrella but in the three other policies. PPG referred to the primary policy, the defendant submitted this was and could only be a reference to the global CS, etc. Now, my lord, in my submission, that is starting off with a presumption in a way which I've criticised. Now, my Lord Justice Phillips has said, well, it surely shouldn't matter, which you do. But in my submission, the starting point for a correct analysis is to look at the policy provisions as a whole. And in my submission, the two critical points are that although there may well be commercial benefits in having an identified single point of jurisdiction, an identified single law, there are also benefits in being able to sue in a number of different places and having the same provisions apply throughout the insurance tower. And I do respectfully criticise the judge from starting off with paragraph 84 with the implicit assumption.
But he's just simply referring to your case there.
Well, my lord, he's summarising my case. The clause 11 should in effect be disregarded because it conflicted with the PPJC. I mean, maybe...
How can you criticise him for starting by referring to what your case was?
Well, my Lord, my case was and is that you start by looking at the process as a whole. You don't start with an assumption that one prevails or the other. What one might ask rhetorically, why doesn't one start with the assumption, is there something in clause 11 or clause 12 which contradicts that which is in the PPJC?
He goes on to consider all the factors quite thoroughly, so I'm not sure that where he starts is a particularly legitimate ground of appeal, is it?
Well,
is he starting with your case?
Well, my lord, if you look at 89, the claimants argued that clause 11 was a clear contractual agreement which was not displaced by the PPJC.
Again, he's citing their case.
And for the reasons which follow, I accept the claimant's argument that clause 11 is a clear contractual which binds the parties is not displaced by the PPJC. I mean, maybe, my lord, I'm shooting at cares. The criticism I'm making, for what it is worth, is that he's starting with an assumption and seeing it's displaced.
Well, I see that if you refer to paragraph 91, there he is taking a start.
Well, my lord, I got what might be referred to as a judicial look just now. I will not from you, my lord, but can I just make this point? The starting point in my submission, it would be fairly described as that clause 11 and the PPJC were both terms which had been agreed between the parties. That would be a fair and neutral starting point in relation to it. It's indicative in my submission of starting with a presumption of one thing, i.e. certainty as to English law jurisdiction being more important than others. That's the reason I'm making the point.
Right, well, if we've reached the starting point, is that a convenient moment?
Well, Lord, yes, and you'll be glad to know that although it's taken me some time to reach the starting point, I have made quite a lot of the points which I had intended to make.
When do you expect to finish?
My Lord, I really would hope that I would finish within half an hour of after lunch. I do need very briefly to deal with the Scottish point, but I've dealt with most of the rest of the points.
Very good. 2 o'clock.
All right.
Sustained.